want to talk about international law. The continued practice of the death penalty is an undeniable illustration of the much vaunted American exceptionalism. The United States today stands nearly alone in the developed world in its use of capital punishment. The Organization for Economic Cooperation and Development, the OECD, comprises today the 36 states most advanced according to financial and social metrics. And of those 36, precisely 2, the United States and Japan, still carry out judicial executions as punishments for crime. The practice has been abolished everywhere else. So for those reasons, international lawyers and international law firms have a particularly powerful platform and a particularly strong perspective from which they may take on the defense of clients on death row. Our next honoree this evening is the quintessential international law firm. It may be the Platonic form of international law firms, and it has brilliantly deployed its international presence in the representation of inmates who, like so many others of the condemned, would otherwise be without not only legal counsel, but also hope. To be a good international lawyer, of course, the first thing you have to be is a good lawyer. White Case lawyers have demonstrated not only their internationalism, but also their exceptional competence, their diligence, and their professionalism in accepting no fewer than 6 death penalty cases. In 3, their client was the Federal Republic of Germany, appearing as amicus curiae to defend German citizens sentenced to death. In 2 others, they answered the call of this project, taking on cases that involved the usual litany of serious prosecutorial misconduct, ineffective assistance of counsel, and credible but undeveloped claims of actual innocence. And what a track record White Case has developed. While it is important, as Emily told us, not to measure the worth of pro bono work on death row cases by the percentage of reversals or commutations or exonerations, because all of us in this room know that successes in this field of endeavor are excruciatingly difficult and sometimes literally impossible to obtain. Still, White Case's achievements are stunning. Charles Christopher Williams in South Carolina, death penalty verdict vacated after the firm did groundbreaking work to demonstrate the consequence of fetal alcohol syndrome. Kimberly Cargill in Texas, a still pending case in which White Case has developed compelling evidence of their client's actual innocence. Justin Underwood in Mississippi, a project case in which the firm located significant, potentially exculpatory evidence never introduced by trial counsel. Joe Franco Garza in Texas, the execution date has been vacated thanks to the firm's tireless work with forensic examiners on scientifically discredited hair evidence. Michael Appelt in Arizona, another pending case in which White Case cert petition concerning the standards for intellectual disability is currently awaiting decision. And Ronald Cawthorn in Tennessee, for whom the White Case team found such serious evidentiary problems as to cause the state to remove the death penalty from consideration on resentencing. In each of these cases, White Case invested thousands of hours of its lawyers' time and substantial financial resources. And significantly, the firm's work on these representations literally spanned the globe. Lawyers from all of the firm's offices in the United States, as well as Berlin, Frankfurt, London, Dubai, Sao Paulo, and no doubt others, pitched in to defend individuals convicted of capital murders in the United States simply because it was, and it is, the right thing to do. This firm is committed to a simple precept. The rule of law requires that before the ultimate penalty is exacted, a defendant must have an opportunity to present his case, to tell his story, and to put the prosecution to the proper test, establishing guilt and eligibility for capital punishment beyond a reasonable doubt. The United States Constitution demands no less, and international law, both conventional and customary, demands no less. Now, before I call upon Jo Weiss, the firm's extraordinary head of global citizenship, note her title, which alone is testimony to the essence of this firm. To receive the project's award, I have to add a personal note. As past chair of the board of the International Law Students Association, I have had the great privilege of working not only with Jo and with Lou O'Neill, the firm's director of pro bono, but also with its visionary chairman, Hugh Verrier, who regretfully cannot be with us this evening. Hugh is an inspiration to his colleagues and a global champion of international law and the international rule of law. But I know that Hugh, were he here, would tell you that this award honors not only the firm's leadership, but its partners, its associates, its staff, and all of its members who share its belief in justice and fairness and equality before the law. It is an honor, on behalf of the Death Penalty Representation Project, to call upon my friend, Jo Weiss, to accept the 2019 Exceptional Service Award presented to the firm of White Case.
Thank you, Steven, for those very kind remarks. And thanks so much to the ABA project for this phenomenal award. On behalf of White Case and our lawyers who did the work, many of whom are here tonight, I'm honored and grateful to accept. When we launched, as Steven alluded to, our global pro bono practice 10 years ago, our objective was to make the practice of pro bono part of the experience of every lawyer in all our offices around the world. We now have 40-some offices in more than 30 countries. And in most of those jurisdictions, pro bono is not common locally, so we had to create it, import it. We also wanted to do pro bono that was something that firms like ours are uniquely positioned to take on, that played to our strengths in our global network. So we looked for cross-border matters. So thank you, Steven, for referencing that, because that's been one of our objectives, as you know. This has led to more than 120,000 hours per year of pro bono in 3 areas: access to justice, promoting good sovereign governance, and serving NGOs in their corporate needs and in achieving their mission. Many of the world's leading NGOs were extremely honored to serve in the environment and social issues of all types. Our work is a mix of local and cross-border matters, of individual representation and class action suits, of legal research and corporate matters. We have set some important precedents and overturned some unjust laws, most notably the Don't Ask, Don't Tell policy of the US military, and a victory for gay marriage rights across the European Union on the basis of a novel argument of freedom of movement. While it is heartening that the death penalty is on the decline in the U.S., it is still the place where the rubber meets the road, where the weakness of the justice system, as you all know, show up in what is literally a life or death situation for one human being. We're so proud of you, our lawyers' incredible work on these matters. And it is you we honor here tonight. We're very pleased. We have a number of associates with us. The partners who have led these matters are so upset that they were not able to attend tonight, but we have associates from Washington and Boston. And you have made a major difference in these matters, as Steven has said, and in each case extending and perhaps saving the lives of people who turned out to be either innocent or given an inhumane and inappropriate sentence not reflective of their circumstances. I commend the work of the Death Penalty Project, which is just amazing and critical to identifying these cases and getting them placed with competent counsel. A representation of Germany on their amicus filings came through Reprieve, another excellent organization, and one of our matters was referred by Mr. Tabak directly. But the fact is that each of these cases, as nobody knows better than the people in this room tonight, should not have gotten to these stages in the first place. As so many of the speakers have referenced, they are filled with examples of incompetence at trial or investigation, and yes, even corruption. A defendant's partial fetal alcohol syndrome not shared with trial attorneys and therefore not the jury. A murder weapon that was a sock, never tested for DNA, although it was in the police possession for years. You guys forced them to do that. Vials of blood mishandled in transport so that one broke and contaminated all the rest of them. Videotape evidence tampered with. Yet these trials all proceeded. There were cover-ups. Personally, as a citizen, a taxpayer, and a human being, I find this disheartening, maddening, and unacceptable in this country. Much is said today about economic inequality, but we know too well that justice system inequalities are also severe and in many cases underlie economic inequality. So we're always asking ourselves, as I'm sure you are as well, which matters could we take on that would make systemic change in these problems? We've done work on body cameras, cameras in courthouses, debtor prisons, solitary confinement practices, and more. Some of these death penalty cases should set precedents because real justice comes when the system works for all. We will never have a perfect system. There will always be errors and human failings. But of course, that is the very reason the death penalty is so problematic. Quite simply, we will never get it right 100% of the time. And this is a place where perfection must be the standard. We cannot execute innocent people, children, or those with intellectual disabilities. And we can never be sure that we are not doing that. The ABA is a powerful voice and one we are honored to help amplify and be part of. We're deeply honored to receive this award. Thank you very much.